complete. Okay. Today we'll probably discuss the sections and some orders because we are discussing from the point of view of prelims. So we will not do sections along with orders like we do. We will do sections. After that, we will discuss orders. Okay, because you have to remember the sections as well as the orders. That's why we will do sections first and then the orders. Okay. Now, any civil procedure code, what does it? What is it about? It deals how a civil suit is to be in fact tried. From the start of the institution of the suit till the end, all the procedures are prescribed under the Civil Procedure Code. Okay. Now it is the Act number 5 of 1908. For the first time, yes, in 1858 it was thought so. Then finally in 1908 the CPC as we know it is there with effect from 1st January 1909. Following amendments, important amendments were done: 1951, 1956, 55, 76 is the 76 is an important amendment, 99 is an important amendment, 2002 is an important amendment. Uh, then 2015 for the last time the commercial court amendment was done. Yes, it is a procedural law. Whether it is exhaustive or not, yes, it is exhaustive, and it consolidates all the laws at present. Whether it is retrospective, no, it is not retrospective, and it is part of concurrent list, that is entry 13. Part of concurrent list, that is entry 13. Okay, and on the recommendation of Malamuth Committee, this 1999 and 2002 amendments were done, and it contains 158 sections. It contains 158 sections and 11 parts and 51 orders. Contains uh, 158 sections, 11 parts, 51 orders, and one schedule. One schedule. Okay. Now next is uh, next is division of the CPC according to the procedure. According to the procedure, these are the division. You may have a look. So pre-trial, order 6, order 7, and then after the institution of the suit, order 4 to order 13, and then during trial, order 14 to 40, and post-trial, order 20 to 21, and then 41 to 47. And these are the uh, suits against different kinds of persons or special category of suits, or 27, 28, 29, 30, 31, 32, 34, 35, 36, like that. Okay. Now, today we'll discuss all the sections. Section 1 to 8 is preliminary, 9 to 35 is suits in general, 36 to 74 is execution, which will be read with order 21, 75 to 78 is incidental proceedings. Now 79 to 88 is suits in particular cases, 89 to 93 is special proceedings, and then 94 to 95 is supplemental, 96 to 112 is appeals, 113 to 115 is reference, review and revision, 116 to 120 is special provisions relating to High Court, 121 to 131 is rules, and 133 to 158 is miscellaneous. Okay, so this is what we will discuss. That these are the sections that we will discuss. Now sections and their relevant orders, that these are there in the table. You may have a look. I need not discuss it. Okay. Now let's come to directly the sections. The section 1 says that it is applicable to the whole of India except Nagaland and tribal area. It is applicable to the whole of India except Nagaland and tribal area, and whether it is applicable to revenue code. Section 5 says that yes, when provisions of revenue code are silent, then state government may by notification deduce that the provisions of CPC will apply or not apply, that the state government may deduce. But for that, first the uh, the provisions of revenue code must be silent. Okay. Now non-application, if there is a special law, local law, special procedure by any law, or jurisdiction by any law, then in that case those will override CPC. Now Whether it is applicable to provincial small causes court, section 7 says that no, it is not applicable to provincial small causes court ordered with order 50. Also, presidential small causes court also, the applicability is not there, applicability is limited. Okay, some provisions are applicable, not all. Okay, you may have a look which provisions are applicable. Now that's all. Next, coming to section 3, that is subordination of court. First there will be Supreme Court, then High Court, then District Court. Under that there is court, civil court senior division, civil judge senior division, and then civil judge junior division. This particular court is called sub judge court, and in popular parlance, and this is called munsif court. Okay, and there is a court of small causes, court of small causes also, court of small causes also. Okay, now so court of junior division, what is the pecuniary jurisdiction? It is 50,000, up to 50,000, and court of senior division is 50,000 to unlimited, 50,000 to unlimited. Okay, now coming to jurisdiction. Jurisdiction is, yes, as I told you, there will be three kind of jurisdiction: pecuniary, territorial, subject matter. Pecuniary is what is the maximum amount that can be dealt under. Territorial is what is the territorial limits, and subject matter is what are the kinds of suits that can be dealt with. Like family court deals with only family disputes. Okay, similarly territorial within Cuttack or within Bhubaneswar, like that. And pecuniary is after according to the value, whether it is 1 crore, whether it is 50,000, what is the value. Okay, this is there. These are three kinds of jurisdiction, and it says that yes, the court shall not exercise jurisdiction over suits whose value or amount of subject matter exceeds its pecuniary limit. That's what section 6 says. So within pecuniary limits, it must be there. Okay. Next, section 9. Section 9, the general rule of jurisdiction to try civil suit. It says that court is to try all suits of civil nature unless barred expressly or impliedly. Okay, so unless it is barred expressly or impliedly, court has to try all suits of civil nature. Now, what is a court of civil? What is a suit of civil nature? Where private civil rights are involved. That's a suit of civil nature. Okay, unless barred, these are the cases where it is barred. Res sub judice, there is a bar. Res judicata, there is a bar. Okay, 12 also it puts a bar on further suit. 21A, you can raise objection as to place of suing. Now, 47 also, question to be decided by court. You don't have to file a fresh suit, you will have to make an application in the same proceeding. 95 also, for compensation you can't bring fresh suit, you have to make an application in the same. An application for restitution, you can't file a suit, rather you'll have to file an application there. So whether it is expressly or impliedly barred, by that, if there are not there anything, no bar, then court has to try suits of all suits of civil nature. Now section 2, it's talking about the definition. Code includes the rules. Decree is formal expression of adjudication of court which conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit, and it may be either preliminary or final. Okay, so if there is a conclusive determination of the rights of the parties, and with that regard there is a formal expression of adjudication of court, and that is done with regard to all or any of the matters in controversy in the suit. That is, one party is alleging something and another party is denying, that is a matter of controversy. And if there is formal expression of adjudication with regard to conclusive determination of the rights of the parties in that, then it will be a decree. And judgment is statement given by the judge on the ground of decree or order. In fact, first judgment comes, and then on that decree is drawn. Okay, now judge is presiding officer of the civil court. Now order is formal expression of any decision of civil court which is not a decree. So order is also a formal expression, but it does not conclusively determine the rights of the parties with regard to all or any of the matters in controversy. So any formal expression which is not a decree is an order. Okay, now decree, I missed out something, that yes, there are some deemed decree as well. So it says that rejection of plaint and determination of any question under 144 will be deemed decree, and these will not be called as decrees. That means it will not include adjudication from which an appeal lies, an appeal from an order, or any order for dismissal for default. These two things will not be included. These two will be included, and these two will be excluded from the purview of decree. That is what section 2, that is decree, says. Now, decree holder is any person in whose power the decree is in whose favor the decree is passed or order capable of execution is made. So, in whose favor the decree is passed or order capable of execution is made, that is a decree holder. Suppose A and B, there are two parties. Now courts decided A had filed that 5 lakh rupees B had taken from him and he is not returning. Now court decides yes, A is to get 5 lakh rupees. So A becomes the decree holder. This decree is of 5 lakh, and B becomes the judgment debtor. Judgment debtor. So anyone who owes the decree is judgment debtor, and anyone in whose favor the decree is passed is the decree holder. He is also called the judgment creditor. Okay. Now foreign court is court situated outside India, not established or continued by the authority of the central government. Now foreign judgment is judgment of the foreign court as per 2.6. Foreign court is 2.5. Government pleader, officer appointed by state government to perform functions expressly under CPC on government pleader, and pleader acting under the direction of the government pleader. He will also be known as a government pleader. Now, pleader is any person entitled to appear or plead for another in court, and it includes advocate, vakil, or attorney of High Court. Okay. Now, 7A says High Court of Andaman Nicobar will be High Court of Calcutta. Now, coming to 4. The local limits of jurisdiction of principal civil court of original jurisdiction includes the local limit of ordinary original civil jurisdiction of High Court. So that's what 4 says. Not that important. Just have to look into it. Now, legal representative. Legal representative is a person who represents the estate of the deceased person, or where a party sues or is sued in his representative character. That is called a legal representative. Okay. Now, mean profits. Mean profits means profits which person in wrongful possession of property actually received or might have received. Okay. So there is a property and B is in wrongful possession of the same. So whatever profits he received or he might have received, is called mean profits. But if he makes certain improvements on the land, then those improvements will not be included in the mean profits. Okay. Now movable property includes growing crops. If you have to look into a more specific definition, then transfer of property section 3 defines it properly. Now rules and forms contained in first schedule or made under 122 or 125 of CPC. Now, share in corporation shall deem to include stock, debenture, and bonds. And signed includes stamped, except judgment or decree. Signed includes stamped as well. Now, who is a public officer? 217. All this category of people: every judge, member of All India Services, commissioned gadget officer in military, naval, or air forces, officer of court of justice, a person who holds any office by virtue of is empowered to place or keep any person in confinement. Now, every person of the government whose duty it is as such a person to prevent offences, or to give information of offences, or to bring offenders to justice, or protect the public health, safety, or convenience. Every officer whose duty it is as such officer to take, receive, or keep or expend any property on behalf of the government, or every officer or service or pay of the government, or remunerated by fees or commission of the performance of any public duty. So these are the people who will be known as public officer. Now, coming to suits in general. Suits in general. Okay. Jurisdiction is 9 to 14, 15 to 25 place of suing, institution of suit 26, 27 to 32. Summons and discovery, 33 is judgment and decree, 34 is interest, and 35 to 35 is B is cost. Section 9. Court to try all suits unless barred. So, if it is expressly or impliedly barred, that is a different thing. Otherwise, it will have to try all suits of civil nature. And what is a suit of civil nature? Suit in which right to property or right to an office is contested. It is immaterial whether any fees is attached to a office or not. Still, then it would be a suit of civil nature. So basically, any individual, any private civil right can be challenged. Any private civil right can be challenged in a suit of civil nature. Section 9 says that. Now coming to section 10, that is res sub judice and res judicata. Res sub judice and res judicata. Section 10 and section 11. Section 10, res sub judice says no court shall proceed with trial of any suit, and here only trial is barred. Okay, in which the matter in issue is also directly and substantially in issue in a previously instituted suit between the same parties under the same title, where such suit is pending in the same or any other court in India. So there is a suit pending between two parties. Now, if another suit is brought, if this particular suit will be stayed. This suit will be stayed, and only this suit will not be tried with. The suit will not be tried with if there is a previously instituted suit which is already pending. But in res judicata, what happens if there is a suit which is already decided on merits? Now he cannot again institute another suit. So this suit institution is barred, as well as if it is instituted, the trial is barred. So res judicata says no court shall try any suit or issue in which matter directly and substantially issue has been directly and substantially issue in a former suit between the same parties under the same title in a court of competent to try a subsequent suit and has been heard and finally decided. So here the previous suit has been heard and finally decided, but in the res sub judice it is pending. Suit is pending. Okay. Now this will just stay in res sub judice. In res judicata it will bar the institution altogether. Okay. Now, explanation of section 10 says suit pending in a foreign court does not preclude the courts in India from trying a suit on same cause of action. And here in section 11, there are 8 explanations which says that former suit will be when it was decided and not when it was instituted. Competent court is a court which has power to decide the matter, and express res judicata is direct res judicata when something is uh, something is uh, directly in issue, and that cannot be a ground of attack anymore. That is express res judicata. Now, constructive res judicata, if a ground of attack which might or ought to have been taken but it has not been taken, then that's a constructive res judicata. That's a constructive res judicata. Okay. Now, if same relief claimed and denied in former, deemed to be denied in subsequent suit also. Now representative suit also, it is applicable to representative suit. Now res judicata applies to execution proceeding as well, and it applies to matter finally heard and decided by the court of limited jurisdiction also. That also you will see under section 11. So section 10 and section 11, res sub judice and res judicata. Now section 12 says that if there is a bar to further suit on any other ground, as in the case of Order 2 Rule 2, Order 9 Rule 9, Order 23 Rule 1, Order 11 Rule 21, Order 22 Rule 9, then if there is a plaintiff is precluded, then he shall not be also entitled to institute a suit for the same cause of action in any court to which the CPC applies, which we'll study later. Under these rules, the suit may be barred by rules. Okay. Now, when foreign judgment not conclusive, section 13, it says general rule is that the foreign judgment shall be conclusive for matter adjudicated between same parties under the same title. Foreign judgment shall be conclusive for matter adjudicated between the same parties under the same title, but except when it is not pronounced by the competent court, not on the merits of the case, opposed to the natural justice, obtained by fraud, or based on a claim of on breach of law in force in India, or incorrect view of international law, then in that case, this foreign judgment will not be conclusive. Will not be conclusive. Other than that, other than that, Yes. So other than that, so now when foreign judgment not conclusive, so foreign judgment shall be conclusive for matter adjudicated between same parties, but if these are obtained by these, then it will not be conclusive. Okay. Now uh, now section 14 is presumption as to foreign judgment. That is says that when there is a certified copy of foreign judgment, then court shall presume that it was pronounced by court of competent jurisdiction unless contrary appears on the record. Then if a foreign judgment is passed and a certified copy of the judgment is pronounced, then court will presume that it was pronounced by a court of competent jurisdiction. Now such presumption may be displaced by proving the want of jurisdiction as well. Now coming to place of suing. Place of suing is court in which every suit to be instituted. Court section 15 says that yes, any court of competent court of lowest grade, competent court of lowest grade. Okay, so any competent court, any competent court of lowest grade will be the suit where the will be the court where the suit will be filed. Now section 16 says that suit will be instituted where a subject matter is situated when suit relates to all this, that is recovery of immovable property, partition of immovable property, partition of immovable property, for foreclosure, sale, or redemption of property, determination of any other right to interest in immovable property, or compensation for wrong to immovable property, or recovery of immovable property, then court within the local limits of whose jurisdiction the property is situated, there the suit will be filed. And section 17 says if there is an immovable property situated within the jurisdiction of different courts, then court in whose jurisdiction any portion of the property is situated, provided it has pecuniary jurisdiction. Now, if jurisdiction of the courts are uncertain, then in that case, any one of those courts. Okay, it's not certain that in which court it can be filed, then it can be filed in any one of the courts. Now, if there is a compensation for wrong to person or movable, then where defendant resides or carries on business or works for personally works for gain, these are the three places where the suit can be filed. And if there is any other suit, then that can be filed where defendant resides or carries on business or personally works for gain or cause of action arises. So these are the places of suing. These will decide the territorial jurisdiction where in fact the suit can be filed. That will be decided by the section 15 to 20, which talks about the territorial jurisdiction, that is the place of suing. Place of suing कटक फाइल हम ना भुवनेश्वर फाइल हम आप जानवे सो ସେଇଟା ସବୁ କହିଦେଲା ଯୋଉଠି ଯୋଉଠି ଅଛି ଯଦି ଏମିତି ଅଛି ଯୋଉଠି ଡିଫେଣ୍ଡେଣ୍ଟ ରହୁଛି ତାହେଲେ ସେଠି ହବ ଗୋଟେ ଏକ୍ସାମ୍ପଲ ନେଇଯିବା ଭାବନ୍ତୁ କମ୍ପେନସେସନ ଫର ରଙ୍ଗ ଟୁ ପର୍ସନ ଯଦି କିଏ ଏ କ'ଣ କରିଛି ବି ନାଁରେ ଡିଫେମେସନ କରିଛି ଦେନ୍ କୋଉଠି ସୁଟ୍ ହେଇପାରିବ ଯୋଉଠି କହିଲା ଡିଫେଣ୍ଡେଣ୍ଟ ରିଜାଇଡ୍ କରୁଛି ସୋ ବି ଯୋଉଠି ରିଜାଇଡ୍ କରୁଛି ସେଇଠି ହେଇପାରିବ और कैरीज ऑन बिजनेस सेट जदी कोठी काम करूची ताले सेठी परिबो और पर्सनली वर्क्स फॉर गेन सेठी परिबो सो से जोटी रहुची कोठी जोटी कैरी बिजनेस करूची किबा पर्सनल वर्क्स फॉर गेन परिबो सो अकॉर्डिंगली यू डिसाइड द प्लेस ऑफ सुइंग बोली से कहिदला नाउ if there is an objection as to the territorial jurisdiction then you will have to take it at the court of first instance and at the earliest possible opportunity and at or before the settlement of issues. At or before the settlement of issues, it has to be done. And the exception is that if there is a consequent failure of justice, then later also it can be allowed. Now, when not allowed in a appellate court or revisional court directly, you cannot file an objection as to place of jurisdiction. Okay, that is what section 21 says. Now, 21A says if you cannot file a suit to set aside the decree on the ground of objection to place of suing. Okay, so yes, you cannot make a suit to challenge the validity of decree on the ground of want of jurisdiction or objection as to place of suing. Okay, you can of course make an objection in the suit itself, but you cannot file another suit that is to set aside the decree on the ground of objection as to place of suing or challenging the validity of the decree on the ground of want of jurisdiction or objection as to place of suing. Okay, so एतिकी कहला तापर आसला ट्रांसफर पावर कोर्ट रे देला सेक्शन 22 ରୁ 25 रे 22 कहला व्हेन अलाउड 23 कहला वेयर टू लाई 24 कहला ऑफ हाई कोर्ट डिस्ट्रिक्ट कोर्ट टू ट्रांसफर एंड विड्रॉल और 25 कहला ऑफ सुप्रीम कोर्ट टू ट्रांसफर बोली कहला कोन कहला यस 22 रे कहला जे if a suit which can be instituted in more than one court then by the application of the defendant at the earliest possible stage or after at or before the settlement of issues after notice to the opposite party this transfer can be done. So dita jagar hei parthanta कटक रही परथांता भुवनेश्वर रही परथांता काहे कि म कहली जोडी जदी अलग अलग जगह रे डिफेंडेंट काम करूची गोटे जगह डिफेंडेंट काम करूची और गोटे जगह रे कॉज ऑफ एक्शन अराइज करूची तले सेठी भी हेई परथांता कटक रे भी हेई परिबो भुवनेश्वर भी हेई परिबो. सो नाउ डिफेंडेंट अप्लाई कर परिबो जे कटक रो ट्रांसफर करके भुवनेश्वर को निया जाओ. सो ऑन द एप्लीकेशन बाय द डिफेंडेंट at the early stage at or before settlement of issues after notice to the opposite party it can be transferred. अब कोर्ट से एप्लीकेशन टा लाई करिवो कहला if the several courts are subordinate to same appellate court then application shall lie to the appellate court. If several courts are subordinate to the different appellate court but same high court then the application shall lie to that high court. And if the several courts are subordinate to different high courts then high court where suit is first brought सेठी की लाई करिवो. सो कटक भुवनेश्वर रे कोठी आपण जदी माने भावंतु कटक आ आठगढ़ दीटा थिला then it is subject to same high court so कटक डिस्ट्रिक्ट कोर्ट रे लाई करिवो. नाउ कटक आ भुवनेश्वर भितर जदी एप्लीकेशन करियार छी ताले लाई करिवो ओडिसा हाई कोर्ट रे. बट जदी कटक आ कलकत्ता भितर अछि देन कटक रो कलकत्ता को ट्रांसफर करिया गेले लाई करिवो where the suit is first brought that is ओडिसा हाई कोर्ट रे सूट ता फर्स्ट आस्तला तो ओडिसा हाई कोर्ट रो यदि कलकत्ता हाई कोर्ट रे सूट आस्तंदा ताले कलकत्ता रे आना है कांदा. नाउ 24 रे कहला जनरल पावर्स ऑफ ट्रांसफर एंड विड्रॉल कोन कहला ऑन द एप्लीकेशन ऑफ द पार्टी after giving notice to the party and hearing them or suo moto without notice to the party kon kari paribe at any stage the high court or district court kon kari paribo transfer kari paribo any suit appeal pending before it and it includes execution of decree or order to any subordinate court direct transfer kar de paribo gote court ro agote or kon kari paribo withdraw kari paribo any suit appeal proceeding pending before subordinate court nije withdraw kari kon kari paribo nije try kari paribo किंबा आ गोटे को सबऑर्डिनेट कोर्ट ट्रांसफर कर परिबो किंबा ट्रांसफर कला परे आथरे रीट्रांसफर भी करि परिबो. ओके नाउ सूट प्रोसीडिंग कैन बी ट्रांसफर्ड फ्रॉम कोर्ट विदाउट जुरिसडिक्शन आल्सो. तो जदी जार जुरिसडिक्शन नहीं से कोर्ट भी ट्रांसफर हे परिबो. सो दिस इज बेसिकली पावर ऑफ जनरल पावर ऑफ ट्रांसफर एंड विड्रॉल ऑफ द डिस्ट्रिक्ट कोर्ट एंड हाई कोर्ट. नाउ 25 से सुप्रीम कोर्ट्स पावर टू ट्रांसफर सेठी किंतु suo moto होई परिबोनी. if the application by party is given and after notice and after hearing then जदी आपण affidavit सहित application दोचंती then from high court or civil court in one state to high court or civil court in any other state को directly transfer हे परिबो. सुप्रीम कोर्ट करि परिबे कोर्ट इतले करि परिबे at any stage of the suit करि परिबे for ends of justice करि परिबे. but if the application is frivolous or vexatious then supreme court can dismiss it and order to pay compensation not more than 2000 is too less but right now it will be done away with when the amended CPC or the next form of CPC comes. Okay, now coming to section 26 kon कहला institution of suit एटा को हम order 4 सहित पढिया कथा. order 4 किंतु हम परे पढिया because हम section wise बे जाउछे. so institution of suit kon कहला केमथि हबो by presentation of plaint or any other manner as prescribed. okay, so it is facts to अपन affidavit द्वारा proof करिवे and you will have to present a plaint. order 4 रे institution of suit रे rule 1 रे कहितला जे suit टा भी plaint रे institute हबो and suit will be instituted by presenting plaint in duplicate in the court of officer appointed and plaint could to comply order 6 and order 7. और register of civil suits रहबो जोतरे कि all particulars of suit will be maintained and numbered according to year and order in which the plaint has admitted आपण से ऑर्डर नंबर रे मेंटेन करी की रखिबे बोली कहला. नाउ सेक्शन 27 टू 32 इज समन्स एंड डिस्कवरी एटा को हमें ऑर्डर 5 से तो पढ़िया कथा. नाउ of course order 7 rule 9 रे कहिछि जे जेतेटा डिफेंडेंट अछंती सेतिकिटा कॉपी देबाक पड़िबो विदिन 7 days कॉपी ऑफ लेंट सेतिका देबाक पड़िबो ऑर्डर 5 रे आपण समन्स करिवे डिफेंडेंट को आ जदी जेल हेतिबो जेल रे थिबो ताले ऑर्डर 9 हिसाब रे करिवे नाउ इफ ऑर्डर 16 रे आपण समन्स टू विटनेस करि परिबे एंड 27 to 32 इज समन्स टू डिस्कवरी एबे 27 to 32 देखा 27 to 32 कोन कहला जे summons to defendant after suit duly instituted जदि suit टा duly instituted हे गला then defendant को summon करा जिवो so that he will come and answer and appear in the suit and answer to the claim that will be issued within that will be done within how many days that will be done within 30 days okay now yes okay now coming to the summons to witness also witness a summon can be done to witnesses as well to give evidence or to produce document that is and here also section 27 28 and 29 would apply now 28 says if defendant resides in other state then summons will be sent to the other court and now he will proceed as if the summons is issued by itself and then after issuing the summons it will return it to the court issuing the summons okay now if the language is different then there will be a translation given along with it that's what it says 29 says service of foreign summons it says that if it is issued by civil court or revenue court and CPC and it is to issue to court outside India or court outside India but CPC applies then it will be sent to the court in the territory to which the CPC applies okay now foreign summons how it will be served that is given in section 29 now 30 says the power of court to order for discovery on application of the party or on motion at any time you can discover impound or return document or deliver any interrogatories or answer any interrogatories okay now this has to be proved by affidavit that we will discuss later in order now if penalty for default if any appearance summons is issued and he is not coming then in that case arrest warrant attachment sale of property or imposition of fine of maximum 5,000 or furnishing security all of these can be done okay now section 34 that is talking about interest okay now interest section 34 says when decree is for payment of money then court may in decree order for interest what kind of interest can be done there can be three kinds of interest that is before the date of suit and then from the date of suit to date of decree and from date of decree to payment this is prior to the institution of suit before the suit this is from the suit to date of decree and this is from date of decree to date of payment okay all of these three interest can be ordered and the principal sum and from date of decree to date of payment not exceeding 6% and if the decree is silent it's deemed that court has refused for such interest and no separate suit to lie in order to get the interest so court has to specifically mention it if court has not mentioned then it will be deemed that it has not given you the interest only so you can't say that I will file another suit altogether again okay now 35 to 35b is cost with respect to cost and that has to be read with order 20a cost is cost plus incident of all suits in the discretion of the court and it can be given to such persons that the court may deem fit court will have power to decide by whom it will be paid out of which property it will be paid and to what extent it will be paid 35a 35b talks about two kinds of cost 35 is compensatory cost for false or vexatious claims and applies to suits or proceeding or execution of proceedings and do not apply to appeal or revision the ground is that any party objects to claim and it is found that the claim or objection is false or vexatious then up to 3,000 rupees or pecuniary limits whichever is less the compensatory cost can be given. Now it is not exempting persons from criminal liability. That is a fact. Now, cost for causing delay: if the party to suit on date fixed for hearing fails to take step uh, requested by the as required by the code, or it does what, it obtains any adjournment for taking step or production of document, then court may order such party to pay cost to other party for expenses incurred in attending court. So this is for causing delay, and this is for making vexatious claims or false claims. 35 is for B is for causing delay. Now coming to the largest chapter of CPC, that is execution, 36 to 74, along with order 21, which has 106 rules. Now 36 37 is general, 38 to 46 is code by which decree may be executed, 47 is questions to be determined by court. Now 49 50 is transferee and LAs, 51 to 54 is procedure and execution, 55 to 59 is arrest and detention, 60 to 64 is attachment, 65 to 67 is sale, 73 is distribution of asset, and 74 is resistance of execution. Now order 21 also, general is 1 to 36, and then procedure of execution is 36 to 96 rule, and resistance is 97 to 106. Okay, all under that all of these headings are there. Let's discuss the sections one by one. It says section 36, if there is any provisions that have been given for execution of decree, it will also apply to execution of order. So for execution of order, no separate proceeding is given. It just says that whatever the proceedings are there for execution of decree, it will also apply to the execution of the order. Okay, now section 37, that court which passed a decree, how you will know that court which passed a decree means it is either a court of first instance if the decree is to be executed, passed by the court of appellate jurisdiction, and court which would have had jurisdiction to try the suit if court of first instance has ceased to exist to have jurisdiction. Then later on, whichever court would have had the jurisdiction, that would be the court of jurisdiction, that would be the court which passed the decree. Okay, now 38 is court by which decree may be executed. It may be executed either by court which passed it or court to which it is sent for execution. Okay, now 136 Limitation Act says that you have to make an application for execution of decree within 12 years from the date of decree. Now section 39 says transfer of decree on the application of defendant or on its own motion, court passing the decree may transfer the decree to another court of competent jurisdiction for execution on following grounds. Which are the grounds? First, person against whom decree passed resides, carries on business, or personally works for gain in jurisdiction of another court. So he is in another court, so it will be better executed there. Now, person has no sufficient property in the jurisdiction of the court passing the decree and has property in jurisdiction of other court. So property against whom the execution could have been actually made, that is not there here, that is there in another court. So it is better served there. Now, decree directs sale or delivery of movable property outside jurisdiction of the court or any other reason, then this case it may be transferred. So court to which decree is sent not sent for execution cannot execute a decree against a person or property outside its local jurisdiction. So it has to be sent, and then only it can be executed. Now section 40, transfer of decree to court in another state, that will be executed in the manner as rules of that state. Okay, so rules of that state will apply. Section 40 says that. 41 says if there is a execution proceeding and the result of it is to be certified by court to whom decree is sent for execution. 42, power of court in executing transfer decree, it has same power as court passing the decree has. Okay, because we studied that both courts can pass it, either the court which passed the decree or to which it is sent for execution. Now execution of decree 43 says that if it is passed by a civil court to place where CPC do not extend, then executed in the manner as provided in the judgment to which CPC applies, jurisdiction to which CPC applies. Now passed by a revenue court to place where CPC do not extend, then state government may declare it to be executed as if decree is passed by court in that state. And if it is outside India, then court can send it to court established by authority of central government outside India, or to which state government declared that section 45 will apply. Okay, now section 46 is important. It talks about precepts on the application of the decree holder. It can be issued by the court passing the decree to another court, so that the property of the judgment debtor, it may be attached for a period of 2 months, unless the period is extended. So precept is basically attaching the property of the judgment debtor, maybe because he may just dispose of it in order to avoid that the decree may not be executed against him. Okay, now 47, questions to be determined by the court executing decree. It says there is a dispute between parties to suit or representative as to execution, discharge, or satisfaction of the decree, or any question relating to delivery or possession of property to the purchaser or representative. Then in that case, all these questions can be determined by the court executing the decree. Now, who can file under section 47? Plaintiff if the suit is dismissed, defendant against whom the suit is dismissed, or purchaser of property at sale in execution of the decree. Both, all of them can file an application for questions to be determined by the executive court executing the decree. Now, transferee of a decree, he will also hold the same position, and he can, against that also it can be uh, enforced. Now, legal representative also, if the judgment debtor dies, then in that case decree holder can also apply to the court for execution of the decree against legal representative, but legal representative's liability will only extend to the property of the deceased which came to his hand. So not out of his personal property, but only of the property that he uh, inherited from the judgment debtor. Only those properties he'll be subjected to liability. Next, 51 to 54, procedure of execution. 51 says that power of court to enforce execution on application of the decree holder, court can order for execution of decree by who, but all of these following purpose, that is delivery of property, attachment and sale, arrest and detention, appointing receiver, or other manner. And where there is execution of decree of payment of money, then no detention in prison unless judgment debtor is likely to abscond or may leave the local limits of jurisdiction, dishonestly transfer or concealed or removed any part of his property, refuses or neglects to pay amount of decree, or decreases for some sum which judgment debtor bound to pay in fiduciary capacity. So if these are done, then only detention in prison can be done. Otherwise, detention in prison cannot be done. Okay. Now, in the above cases, judgment can be detained in prison in execution of decree for payment of money. In other cases, it cannot be done. 52, enforcement of decree against legal representative. If judgment debtor dies, then if it is a decree for payment of money, then by attachment and sale of property of deceased, it can be done. Now, 53 is liability of ancestral property. When property is in hands of son or other descendant, then they are also liable under the, if they are also liable under the Hindu law for payment of debt of deceased ancestors, then in that case that can be done. Otherwise, liability of ancestral property as such is not there. Okay. Now, the if there is a partition of estate or separation of share, then in that case 54 says that if the such partition to be made by the collector according to the law in force, it can be made. Okay, so now coming to yes now coming to section 55 to 59, which talks about arrest and detention. Of course, it has to be read with rule 37 to 40 later, which we'll discuss tomorrow. Now, arrest and detention of whom can be done? Of judgment debtor can be done, and it can be done in any execution of the decree. When it can be done at any hour on any day when brought before the court, then it may detain him in civil prison. Now, rules for arrest: you can't enter into the dwelling house after sunset or before sunrise. You can't break the outer door of the dwelling house occupied by the judgment debtor unless he refuses its access. If occupied by a Pardanashin woman and not the judgment debtor, then give her notice to the withdraw. And if the decree is for payment of money on arrest of judgment debtor, if he pays the amount or cost, then release him at once and you don't arrest him. That's what it says. Now 56 says prohibition of arrest or detention of woman in execution of decree for payment of money. You can't arrest or detain a woman in execution of decree for payment of money. Now talks about a subsistence allowance that it has to be paid to the judgment debtor. It is a peculiar case. The decree holder will pay the subsistence allowance. Okay, so which will be decided by the state government according to rank, race, or nationality. So you have to pay a subsistence allowance, and if you don't pay the subsistence allowance, then he cannot be detained in civil prison. Now, detention and release. Judgment debtor can be detained in civil prison for how many days? 6 weeks if it is more than 2,000, but up to 5,000, and not more than 3 months if amount is more than 5,000. After this, the judgment debtor may be released. How it will be released? If he pays the amount mentioned in the arrest warrant to the officer of civil prison, or when the decree is fully satisfied in order of court, or on request of person on whose application he has been detained, or on order of the court. Next, on omission to pay subsistence allowance of decree holder also, it can be released. He can be released. He cannot be detained further because the decree holder is under a duty to pay the subsistence allowance. Now, release on ground of illness. Yes, state government on the ground that there is an infectious or contagious disease can release him, or the court who has committed him to prison on the ground of serious illness can also release him. Now, release of judgment debtor does not mean that he is discharged from his liability. He can be rearrested again. Section 60 to 64 is attachment of property. It says if there is a property liable for attachment or sale in execution of decree, then how it will be done. It says these things can be attached, that is land, house, building, money, bank note, bill of exchange, check, hundi, promissory note, government security bond, security for debt, money, share in corporation. Okay, all sellable properties, movable, immovable, all of these can be attached. But what cannot be attached? This is 1 to 14. Wearing apparel, cooking vessel, bed, wife and children of judgment debtor, tools of artisan, implements of husbandry and such, cattle and seed grain, agricultural produce, houses, books of accounts, a mere right to sue for damages, any rights of personal service, stipends and gratuities of pensioners, wages of laborers and domestic servant. Now, salary also cannot be attached up to the extent of one third in execution of decree of maintenance. Now, pay and allowances under Army, Navy, or Air Force Act, compulsory deposits, allowance forming part of emoluments, and expectancy of succession by survivorship, right to future maintenance, all of these cannot be attached. Now, section 60 to 64 is attachment of property. It says partial partial exemption of agricultural produce. What it says that here it is given by state government. If it is not given by state government, then it cannot be done unless the next harvest for cultivation of land is enough to support judgment debtor and his family. 62 says that seizure of property in dwelling house. So you can't enter dwelling house after sunset, before sunrise, but before breaking outdoor, you have to first ask that whether he is giving access, and notice to be given to the Pardanation woman to withdraw and allow access from access room for the seizure of property. And now property attached in execution of decree in several courts, then claimed to be determined by court of highest grade and or court which first attached property. Okay, that was 63 says. 64 says that private alienation after the attachment to be void. So once it is attached, then private alienation cannot be done, which we will discuss after in attachment before judgment, and here in attachment while a decree is being executed as well. Now 65 to 67 talks about sale, that purchaser's right when immovable property sold in execution of decree and sale becomes absolute, then property shall be deemed to be vested in purchaser, and at the time when the property is sold, and not when sale becomes absolute. So when the property is sold, then only from that date only the property will be deemed to be vested if the immovable property is sold in execution of the decree. Okay, later on the sale may be declared absolute, but whenever it is sold, the property may be deemed to be vested in the purchaser on that date when the sale was made. Now, state government can make rules as to sale of land in execution of decree for payment of money. Now, distribution of asset. If more than one person makes an application to court for execution of decree for payment of money against the same judgment debtor, then assets will be ratably distributed among them all. Okay, because now there are more persons which are applying against the same debt judgment debtor, so ratable distribution of assets will be done. 74 is resistance of execution. If decree holder for possession of immovable property or purchaser of immovable property sold in execution of decree is registered or obstructed by judgment debtor or anyone on his behalf, then court will detain judgment debtor or person on behalf in civil prison for 30 days. So you can't detain execution, you can't resist the execution. If you do it, then civil prison for 30 days, or decree holder or purchaser can be put in the possession of property as well. Coming to 75 to 78, that is commission. It has to be read along with order 26. Here it says that court has power to issue commissions in order to examine any person, order local investigation, examine adjust accounts, make partition, hold scientific, technical, or expert investigation, conduct sale of perishable goods, or perform ministerial act. All of for this commission can be issued. Now, commission is what? Commission is basically court cannot go to certain places, so hence it issues a commission so that it will observe something on behalf of the court. Now, commission can be sent to another court also, but it has to be verified that it is not an high court. If it is situated in other state, it can be sent. Now, letter of request can be made also. That is, court may issue letter of request to examine a witness who is residing outside India. Now, of course, if a commission by foreign court, then also it can be issued by court in India, but where CPC does not apply, then also it can be done. That is given in 78. Now, suits in particular cases, suits against government or public officer, by or against government or public officer, suits by or against alien, foreign ruler, ambassador, or envoys, and suits by or against rulers of Indian state, and then interpreter suit. These are the kinds of suits in general. What is it? What does it say? Yes. Now, yes, Order 27 and Section 79 to 82 deals with suits by or against government or public officer. 79 says that if it is against the central government, then Union of India is to be made a party. If it is against state government, then state of that will be made a party. Now, Section 80 says that notice has to be given if there is a suit against or by the government or public officer for act done in official capacity, then a 2 month notice has to be given, and on expiry of that only suit can be instituted. And if the suit is against the central government, then notice to be given to the secretary of government. If the suit is against railway, then general secretary of railway. If it is against the government of Jammu and Kashmir, then chief secretary of that government. If it is against any other state government, then secretary of that government or collector of the district. If it is against any public officer, then deliver it to him personally or leave at his office. Now, Section 81 says that yes, no, sorry, continuation of Section 80 is yes, if suit is for suit is of urgent nature and immediate relief against court is to be taken, then if court permits, then no notice is to be served and the suit can still be filed. But after hearing the parties, if court finds that no immediate relief is to be granted, then court may return the plaint and ask for the plaintiff to comply with the serving of the notice and then come back again. Section 81 says that there are certain exemptions from personal appearance, arrest, or attachment of property. That it says that if he cannot be present without detriment to the public service, then he cannot be directed to personally appear, and if he except in execution of decree he cannot be arrested, and except in execution of decree his property also cannot be attached. Okay. Now, coming to yes, and Section 82 says that while execution of decree, if it is passed against Union of India or state, then it shall not be executed 3 months until 3 months has expired from the date of the decree. It shall not be executed. Okay. Now, coming to Section 83 to 87b, which is sued by alien or foreign ruler or ambassador of envoy. ambassador or envoy. 83 says that when alien may sue, alien enemy living in which are staying in India and alien friends can sue with the permission of the central government. Now, when foreign states may sue to enforce private rights vested in ruler of state or any officer of state in his public capacity, they may sue as well. 85 says that persons specially appointed by central government to prosecute or defend on behalf of foreign rulers, they will be deemed to be a recognized agent and they may also sue. Now, suits by suits against foreign ruler in envoys and ambassadors, those can be done only with the consent of the central government once it is certified in writing by secretary of government, and consent may not be given if central government, if it appears to the central government that uh, the foreign state has instituted suit against person desiring to suit it, or trades within local limits of jurisdiction of the court, or is in possession of movable property um, in local limits of jurisdiction and sued in reference to such property, or if it is expressly or impliedly waived the power given it to it by this section to sue without the permission of the central government. Okay, and without the consent of the central government, no decree to be executed against the foreign state. And following not to be arrested under this code, that is any ruler of foreign states. Now, ambassadors or envoys or high commissioners of Commonwealth country, all of these cannot be arrested as well. Now, 87 states that yes, they may sue or be sued in the name of the state. That means they don't have to be sued individually. Foreign rulers may be sued in the name of the state. 87A says if there is a foreign state, that foreign state is a state outside India but recognized by the central government. Foreign ruler is person recognized by the central government to be head of the foreign state. Now court shall take judicial notice of the fact, and if the state has or has not been recognized by the central government, or person has or has not been recognized by the central government to be head. 87B is section 85-86 to apply to rulers of former Indian states. This is not important, just have to look into it once. Now, section 88. 88 is important. Interpleader suit. It has to be read along with order 35. When it has to be made, when two or more persons claim any debt, money, or property, that is movable or immovable property, from another person who claims no interest, except charge or cost, ready to pay and deliver to the rightful claimant, then he may institute a interpleader suit. So A is a person who is holding this property, but he is saying this is not my property. In fact, B out of B and C, one of these persons are owner of this property, are entitled to this property. So he will file an interpleader suit and say that uh, out of you please take it from me, whoever is rightfully entitled. Court may order, and I will give the delivery of that particular thing or property to him, because I don't claim any interest therein, and to the rightful claimant I am ready to give. That is an interpleader suit. Okay, so he will institute a suit against all claimant for obtaining decision as to person to whom payment or delivery shall be made, and obtain indemnity for himself, that is charge for whatever he had incurred, that he may take it. Okay. Now, when interpleader suit cannot be instituted, when already suit is pending between parties to decide their rights. If a suit is already pending between B and C, then of course A can't institute a suit again, and he only has to deliver it to them. He doesn't have to institute a suit altogether. Now, coming to 89, settlement of dispute outside the court. It says that this is in fact ADR, alternate dispute resolution methods, where it appears to the court that there is an element of settlement. Then court may refer the same for arbitration according to Arbitration and Conciliation Act, conciliation under the same act, judicial settlement including Lok Adalat under the Legal Services Authority Act, and mediation here normally referring to the compromise between the parties. It can be sent as well. That is what section 89 says. Okay, it has to be read along with order 10, rule 1A, 1B, and 1C, which we'll read later. Now, 91 to 93, public nuisance and wrongful act. It says 91, yes, if there is a public nuisance and wrongful act, then there can be a suit for declaration, injunction, or other relief, and it can be instituted by whom? Either the Advocate General or two or more persons by leave of the court, whether damage or caused or not, then a suit can be filed. And 92 says public charities, suit may be instituted by Advocate General or two or more persons by leave of the court for breach of any express or constructive trust created for the purpose of charitable or religious nature. Here also, Advocate General or two or more persons can file who are interested in the trust. They may file. They may file. Okay. Now, yes, that is what is given. Public charities with respect to that you can file, and 91 is public nuisance also you can file. Either Advocate General or two or more persons can file. 94 to 95 is supplemental proceeding. Supplemental proceeding are the intermediate proceeding, or you whatever proceedings you do in order to protect the subject matter. In those are the intermediate. Like in criminal cases, bail is filed. In civil cases, all these supplemental proceedings are done. To prevent ends of justice from being defeated, court may do all of these. That is warrant of arrest against the defendant, arrest before judgment. This is attachment before judgment. This is temporary injunction. This is appointment of receiver. This is any other interlocutory order. Okay. This is also order 39. Rule 6 to 10. This is 39 1 to 5. This is 1 to 5, and this is the rest, I think. Okay. Now 95 is compensation for obtaining arrest, attachment, injunction on insufficient grounds. If the plaintiff fails and there is the petitioner fails and no reason to institute the suit, plaintiff fails and it is shown that yes, there was no reason to institute the suit, then in that case, and he has obtained this arrest, attachment, injunction on insufficient grounds, then up to 50,000 compensation can be given, or not exceeding the pecuniary jurisdiction of the court, compensation can be given. Okay. Now, if such order is determined, then no separate suit for wrongful arrest or attachment or injunction can be done. No separate suit can be brought. Other, just that you have to make an application. Okay. Now appeal. Appeal 96 to 112, order 41, 42, 43, and 45. 41 says that appeal from original decree. Appeal from original decree 96 to 99A, which is called first appeal. Now, order 42 is appeal from appellate decree 100 to 103, which is called second appeal to High Court. Order 43 is appeal from order 104 to 106, and order 45 is appeal to Supreme Court 109 to 112. 107 to 108 are general provisions. Now, what are the general provisions? General provision says that what are the powers of appellate court? The powers of the appellate court include that it can determine the case finally, it can remand the case back. That means it can ask the previous court to say that you try it again. Second, it can frame issue and refer back to trial, so it can send it again to trial, or it may take additional evidences also. 108 says that provisions of appeal from original decree to apply to appeal from appellate decrees or orders as well. Okay. Now that's what 108 says. Now 96 to 99A, order 41 is appeal from original decree. It says 96 says that appeal from original decree will be made to court authorized to hear appeal. Okay. Now appeal may lie from every decree passed by court of original jurisdiction or original decree passed ex parte. That appeal may lie, but no appeal will lie to which cases. No appeal may lie in decree passed with consent of the parties. So consent decrees, no appeal can be made, and decree passed by small causes court when amount or value is not less than is less than 10,000, then in that case appeal may not lie. Okay. 97 says that appeal from final decree cannot be made if there is no appeal from the preliminary decree regarding its correctness. It cannot be made. It cannot be challenged. The correctness cannot be challenged if in preliminary decree no appeal has been made. Then from the final decree also appeal cannot be made. Now 98 is decision where appeal heard by bench of two or more judges. Then it has to be decided by the majority, and if no majority, then decree shall be confirmed. Okay. Now 99 says that no decree to be reversed or modified in appeal just because there is a non-joinder, misjoinder, cause of action, non-joinder, misjoinder of cause of action, or error defect or irregularity, they do not affect in they do not affect the or they do not affect it, and it is not to be reversed or modified unless there is a miscarriage of justice or it affects the uh, merits of the case, then only it will be decided, otherwise not. 99A says that no decree under section 47 to be reversed or modified unless decision of the case is prejudicially affected. 47, that is questions to be determined by executing court, those cannot be reversed or modified as well. Now order 42, 102, 103, appeal from appellate order. 100 says second appeal. What does it say? That yes, it will lie to high court. It will lie to high court from court subordinate to high court on the ground that case involves substantial question of law, and it may also lie from ex parte decrees. Just a second. Yes. Next, um, yes, so second appeal will lie to High Court from court subordinate to High Court on the ground that case involves a substantial question of law and may also lie from ex parte decree as well. Second appeal, but no second appeal. It has been given that under 101 on any other ground, second appeal cannot be made, and when suit is for recovery of money not exceeding 25,000, then also second appeal to High Court cannot be made. 103 says power of High Court to determine issue of fact. Now, if it has been not determined by the appropriate court or court of first instance, or appellate court or court of first instance, or which has been wrongly decided or determined by court, then in that case, high court also can determine issue of fact, but that too only in only a limited sphere. Now, order 42, rule 1 says that procedure of order 42 same as under order 41, and rule 2 says power of court to hear appeal on questions formulated by it under section 100. Now, order 43 is appeal from orders. Section 100 to 106 deals with it. 104 says order from which appeal lies. It says order passed under section 35A, that is compensatory costs. 91, 92, that is refusing leave to institute suit for public charity or for public nuisance. Now, 95, compensation for arrest, detention, or injunction on insufficient ground. Next, for imposing fine or directing arrest, detention, except arrest or detention in execution of decree, or order made applicable under section or under order 43. All these will be applicable orders. Okay. Now, no second appeal from order passed in appeal under section 104. 105 also says other orders. In case of other orders, no appeal from order made by court in original jurisdiction or appellate jurisdiction, except where the decree has error, defect, or irregularity of order and it affects the decisions. 106 says to which court appeal lie from order, to which appeal from decree lies, in which the decree is made, in which the order is made, or if order made by court which is not in high court in appellate jurisdiction, then through the high court the this appeal can be made. Now order 43 rule 1 says mentions about appealable order. So other than these sections, that is 35A, 91, 92, 95, etc., under order 43 rule 1 also many things have been given which are made appealable, that is return of plaint, set aside dismissal, set aside ex parte, non-compliance of order of discovery, decree for execution of document, set aside sale, set aside ex parte order, refuse to set aside dismissal, allow, refuse to leave to continue suit, rejecting appeal. All of this you may see on furnishing security, discharge, injunction, breach, appointment receiver, readmission, order granting review. All these are appealable orders and appeal may be made against such orders. Now you have to remember that all decrees are appealable, but orders will be made appealable only if it is provided. Okay, orders are not appealable by its nature. Only if it is provided, then only they are appealable. Now, order 45, section 102, 109 to 112, it is talking about appeal to Supreme Court. It says that when appeal may lie to Supreme Court, that is from the judgment, decree or order in civil proceeding of High Court, if High Court certifies that case involves a substantial question of law of general importance and said question is to be decided by the Supreme Court, then only the Supreme Court will decide it. Okay. Now, decree will be meaning decree plus final order, and here you have to give an application to court from whose decree a complaint is made to. Now Supreme Court will conclude the petition within 60 days. Now if you have to obtain a certificate from court as to fitness or value, that the case involves a substantial question of law of general importance or state question to be decided by Supreme Court. Now, effect of refusal to grant certificate, it will be deemed that the petition is dismissed, and effect when certificate granted, and court can order here that you have to give a security or deposit an amount, and then from the within 90 days from the date when the decree is complained, or from this period of 6 weeks from the date of grant of certificate, you have to give a furnish a security, and then you can file an appeal to the Supreme Court. Now order 46, that is section 113, reference. Also reference is done to High Court. Here it can be done by any court. So here court makes it it refers it to High Court when court thinks that the question is as to validity of any act, ordinance or regulation, but or it is invalid or inoperative, but it has not been declared by the High Court, then reference can be made to the High Court. Rule 1 says reference to High Court when question of law is in suit, appeal or execution of decree, court may proceed or stay the proceeding. Here court may either proceed or stay the proceeding, and judgment of the High Court is to be transmitted into the court which had made the reference, and court will dispose the case accordingly. Now court has the power to alter, cancel or set aside the decree or order passed by the court making the reference. Now power to refer to High Court, that is question as to jurisdiction of small causes court also, that can be referred. Now section 114, that is review is done by the same court, not to any other court, that is but to the same court. So decree or order of court from which appeal lie but no appeal has been preferred, or decree or order from which no appeal is allowed, or decision on reference from small causes court, here person may apply to same court to review. Person may apply to same court to review on the ground that it was not within his knowledge or could not be produced when decree or order was made against him, or on the discovery of new matters or evidence, then in that case this can be done. Now form of review is same as appeal, and if grounds of review not sufficient, then the application may be rejected, and if it is sufficient, then give notice to the opposite party and then hear it. Now application for review decided by 2 or more judges and opinion is equally divided, then application is rejected, and if their majority is agreeing, then application to be decided by the majority. Now bar on review of decree or order. Once review is done of that order, you cannot file another review. That's what it says. Now 115 revision. Here of course there is no order, and it is always with respect to the jurisdiction. Here what can High Court do? High Court can call for record of cases if it is decided or any order during the suit by its subordinate where no appeal lies. You have to remember that when appeal is provided, there is no provision of revision. Okay, here if there is a jurisdiction exercise, he has exercised a jurisdiction which is not vested in it, or failed to exercise the jurisdiction which is vested in it, or is acting illegally or did irregularity while exercising the jurisdiction, then this revision can be made. Now revision do not automatically stay the proceeding before the court unless High Court itself stays it. Okay, now 116 to 120 provisions relating to High Court not being court of judicial commissioner. It says that party applies only to High Court not being court of judicial commissioner. Now provisions of CPC shall apply to High Court. 118 says High Court can do this, or that is execution of decree before ascertainment of cost in its original civil jurisdiction. Now 119 says unauthorized person not to address court on behalf of another. Okay, now because it is not a PIL, so only locus standi has to be checked, otherwise you cannot address on behalf of other, you cannot address. Now section 120 says 16, 17, 20 not to apply to High Court in exercise of original civil jurisdiction. So high courts, even though there is no place of suing no territorial jurisdiction, still then High Court may do it. That's what 120 says. Okay. Now, part 10 is 121 to 131 rules. It says that yes, effect of rules in schedule as enacted in body of CPC. Now there is a rule committee. It is to be constituted under 123, which will sit at the usual place of sitting of each high court. Composition will be 3 high court judges, 2 legal practitioners, and 1 civil court judge. Now high court will make powers as to high court has the power to make rules for its own procedure and procedures of the subordinate courts, and it can also have the power of general superintendence. That was 122 says. Rule committee will report to high court. That's what 124 says. 125 says high court other than section 122 has power to make rules as determined by the state government. 126 rules subject to approval of state government, and 129 says power of high court to make rules as to the original civil procedure. 130 says that power of high court to make rules as to matters other than the original procedure also high court can. So high court can basically make rules in this regard. Now 130 to 150 is miscellaneous. 132 talks about exemption from personal appearance of women. So anyone who is a Parda Nashil lady or not compelled to appear in public, he cannot be done except he cannot be accepted asked to appear personally except when arrest in execution of civil process in any case, or in which arrest of women is not prohibited. Now 133 it talks about VIP category of people who cannot be allowed to appear personally. That is 133 president, vice president, speaker, administrator of union territory, union state minister, judge of Supreme Court, High Court, speaker, chairman of state legislative assembly, or state legislative council. All of these cannot be also asked to appear. Okay. Now exemption from arrest, read with order 38, that yes, if there is a judge, magistrate, judicial officer while going or returning to court, he cannot be arrested. Pleader, mukhtar, revenue agent, recognized agent acted um, in accordance with the summon, they cannot be also arrested. 135A says that legislative body is also exempted from arrest. 136 says that procedure of arrest or attachment, when the person is outside the district, then what may be done? Court may issue the arrest warrant or order of attachment, and it will send to the district court where the person resides or property is situated, and that court can cause the arrest or attachment to be made by its own officer or through any subordinate court. And now on the arrest, it will be sent to the court issuing the warrant, and it may be released on furnishing security. Now 137 says the language of the subordinate court will be same as to high court, which was at the commencement of this court, except when state government directs. Okay. Now power of high court to require evidence to be recorded in English in cases in which appeal is allowed. That can be high court can direct that you will have to record in English. 139 is oath on affidavit by whom to be administered. So oath can be administered by any court or magistrate, notary appointed by under Notaries Act, officer appointed by high court, and officer appointed by state government. These are the people by whom the oath can be administered. Now 141 is procedure for miscellaneous proceeding in court of civil jurisdiction. Procedure as given in this code do not include proceeding under Article 226. Now all order notice has to be in writing. That's what 142 says. Now postage chargeable on notice or summons or letters to be paid on time. That's what 143 says. 144 is that if you are applying for a restitution, you can't file a different suit. Only application is to be made, and if the decree or order is varied, reversed, set aside, or modified in appeal or revision, then any party may give an application for restitution to be made. Okay, restitution is restoration basically. Okay, wherever the court which court had passed the decree or order, to that court only restitution application can be made. Okay, now what orders can be passed? The party can be put in position in which it have been, and or the cost will be refunded, or payment of interest, damages, compensation, mean profits can also be ordered. This is what 144 is about. Now 146 is proceedings can be by or against representatives can be also done. So representatives can also file or can be sued on behalf of the original claimant. Now 147, that if there is a consent or agreement given by the person under disability with the leave of the court by next friend or guardian, then it has to be held as if there is no disability at all. 148 a inserted caveat, that is, to caveat means to be aware. So here if the applicant is expecting that yes, any application is to be made or has been made in the suit, then any person claiming the right to appear before the court or hearing such application may lodge a caveat. It will say that you give a notice to me before passing any order. So it will be valid from the date of when it was lodged up to 90 days. Otherwise, you have to file a fresh caveat. Now, power of court 148, it can enlarge the time up to 30 days. 149, if the court fee is deficit, then it can make deficiency of it at any stage. It can allow to pay, and it will be having effect as if it is paid on first instance. Now, transfer of business to any other court, same power as that of the court which transferred the business. So from one court, if it's transferred to other court, the other court also have the same power. 151 is the inherent power of the civil court. This is important, that any court may make order necessary for ends of justice or preventing abuse of process of the court. It can make any order, that is called inherent power of the court. 152 is amendment of judgment, decree, or order. If any clerical or arithmetic mistake is there, then it can be amended either on its own motion or on application by parties at any time. 153 is general power to amend. Here, any defect or error in proceeding to determine real question, that can be general power to amend. And 153 is that power to amend decree or order where appeal is summarily dismissed by appellate court. And 153 is place of trial deemed to be open court. That's what it says. Now 157 is continuance of orders under repealed enactment. So whatever orders are passed under repealed enactment, it will have same effect as they have been made under CPC 1908. So it's basically a saving clause. Now 158 is reference to CPC or other repealed enactment will be taken to be made to CPC 1908 or its corresponding part or order section rule. Okay. Now coming to orders, we'll start it as well because tomorrow otherwise it cannot be finished. So yes, order 1, parties to the suit. 2 is frame of suit. 3 is recognition and pleader. 4 is institution of suit. 5 is issue and service of summons. 6 is pleadings. 7 is plaint. 8 is written statement. Along with that, it is also talking about the counterclaim, etc., which can be made. 9 is appearance of parties and non-appearance. 10 is examination of parties. 11 is discovery and inspection. 12 is admission. 13 is production, impounding, return of documents. 14 is settlement of issues and determination of suit. 15 is disposal of suit at the first hearing. 16 is summoning and attendance of witness. 16 is attendance of witness confined or detained in his prison. 17 is adjournment. 18 is hearing of the suit and examination of witness. 19 affidavit. 20 judgment and decree. 28 cost. 21 is execution of decrees or orders. 22 death, marriage and insolvency of parties. 23 withdrawal, and 24 is payment into court. 25 is security. Now 26 commission. 27 is government. 28 is substantial question of law. 27 is substantial question of law. 28 is military, navalmen, airmen. 29 is corporation. 30 farm. 31 suits by or against minors and 31 is trustee, executive administrator. 32 is minor unsound mind. 32 is family matters. 33 is indigent person. 34 is mortgage. 35 is interpleader. 36 is special case. 37 is summary. 38 is arrest and attachment before judgment. 39 is temporary interlocutory. 40 is appointment of receiver. 41 is appeal from original decrees. 42 is appeal from appellate decrees. 43 is appeal from orders. 44 is appeal by indigent person. 45 is appeal to the Supreme Court. 46 reference. 47 review. 48 miscellaneous. 49 Chartered High Court. 50 Provincial Small Causes Court. 51 Presidency Small Causes Court. These are the orders. Now coming to order 1. Order 1 is talking about parties to the suit who may be joined as plaintiffs. Rule 1 says that yes, if there is a right to relief in same transaction or there are common question of fact or law would arise, then all persons may be joined as plaintiff or defendant, or if separate suit is brought, then they may be also joined as plaintiff. Now, who may be joined as defendants if right to relief in same transaction arises against him or common question of fact or law would arise against him, then all persons may be also joined as defendants, or if separate suit is brought against them, then they may be also joined. Now, court has power to order for separate trial. That means even though joinder of plaintiffs are done, then rule 2 says if it is embarrassing or delaying the trial, then court may order for separate trial. Now, rule 3 says if the joinder of defendant is delaying or embarrassing the trial, then court may also order for separate trial if it embarrasses or delays the trial. Okay. Now, rule 4 says court may Court may give judgment for or against one or more joint party. And Rule 5 says that the defendant need not be interested in all the relief claimed. That is, it talks about the concept of pro forma defendant. Pro forma defendant is a person who is not interested in any of the reliefs. Now, Rule 6 is joinder of parties liable on same contract. Rule 7 is if the plaintiff is in doubt against whom the relief is to be sought, then he can join all defendant and then court will decide as to who is liable. Now, Rule 8 is representative suit. Here, one person may be sued on behalf of the other with the permission of the court, and court may itself direct the parties to give notice to all interested person as to institution of suit, and it can be done by personal service, or if personal service is not practicable, then by public advertisement. And if the representative do not proceed with the due diligence, then court may substitute him by interested party, and decree under representative suit is binding on all persons as well as in given under res judicata also. Res judicata explanation also dealt with same. Now, misgender, non-gender, there are two parties, necessary parties, without whom no decree at all can be made, and proper party is a party without whom a decree can be made but no proper and effective adjudication of the suit can be made. Okay. Now, necessary party, if he is not joined, then the suit may be defeated. But other than that, for non-joinder or misjoinder of any necessary party or proper party, suit will not be defeated. So, for misjoinder of necessary party, it will not be defeated, or for non-gender misgender of proper party, it will not be defeated. Okay. Now, next is objection as to non-gender or misgender. If there is any objection as to misgender or non-gender, then it has to be taken at the earliest possible opportunity, at or before the settlement of issues if grounds arise afterwards. And if no objection is raised, such right is deemed to be waived. Then only you have to take an objection. Otherwise, if you don't, then it will be deemed to be waived. Suit in the name of wrong plaintiff. Now, the court may substitute or add plaintiff, or court may strike out or add plaintiff. That is called transposition of plaintiff. Transposition of plaintiff can be done as well if you think it can be done. Here also you can transpose the plaintiff, that is make one defendant the plaintiff or make plaintiff the defendant. Now, power of court to request any pleader to address it. If the party is not represented by a pleader, then court may appoint a amicus curiae also. That is done. Now, Rule 12 is appearance of one of several on written authorities. It may say that if one of the parties are not present, it may say that you may be allowed to appear on behalf of the others. Okay. Now, it is not a representative suit. He is just allowed to appear on behalf of the other. Now, order 2, frame of suit. How suit is to be framed? In the manner provided, so that it will provide the ground for final decision and prevent further litigation. So, with this in mind, the suit is to be framed, and suit has to include the whole of the claim. And if plaintiff relinquishes a part of the claim, or he omits to sue for any claim, then afterwards he cannot sue for the remaining portion of the claim or relief so omitted. Okay. But if he omits to sue in respect of the relief, and that after taking the permission of the court, then he can later file for that relief. Now, joinder of cause of action, that by plaintiff, if it is in the same suit against the same defendant, then in that case it can be the cause of action. If multiple, they can be joined. Okay. If cause of action is united, then the jurisdiction will be as per the value of the subject matter, and at the date of the institution of the suit, it will be that. Which claims is to be joined? It says claim for mean profits or areas of rent, damages for breach of contract, or relief claimed in based of cause of action. These may be joined. No other claim to be joined without leave of the court, that for recovery of human property. Now, power of court to order separate trial. Even if jointer of cause of action are done, if it embarrasses or delay the trial, then in that case separate trial may be ordered. And if you have any objection as to misjoinder of cause of action, then at the earliest possible opportunity it has to be taken, at or before settlement of issues it has to be taken, and if no objection is raised, then it will be deemed to be waived. Order 3, recognized agents and pleaders. Rule 1 says that appearance by party in person, recognized pleader or pleader, and he will be appearing or give application or act on behalf of the person or party in court. Recognized agent is given in Rule 2. It says that person holding power of attorney which authorize him to act, or person carrying trade or business in name of person not residing within jurisdiction of the court in which he has to appear. Okay. Now, rule 4 is appointment of pleader. Person party is recognized agent other than authorized person. Power of authority. Uh, in writing, it can be appointed. So, any pleader who is appointed also he can appear, and that will continue. So, it is through Vakalatnama he is appointed, and it will continue until it is determined or until the client dies or pleader dies or proceeding is over. Now, service of summons can be done on the party, on the recognized agent, or on the pleader as well. Okay, and pleader can appear in the court only after filing the memorandum of appearance. Now, section 26 talks about institution of suit. The related order is order 4. So, section 26 is that it will be done suit. How will it be instituted? By presentation of plaint or any other manner. Now, facts shall be proved by the affidavit. Order 4 says that suit to be commenced by plaint and suit to be instituted by presenting a plaint in duplicate in court or officers appointed, and plaint to comply orders 6 and 7. Now, register of civil suits will be there, which the court will enter particulars of suits in this book and number according to year and orders in which plaint is admitted. 27 to 32 we had already discussed. Now, order 5, that is issue and service of summons. Rule 1 to 8 talks about issue of summons. Rule 9 to 30 talks about service of summons. Rule 1 says summons when issued, when suit is duly instituted. To whom? To the defendant. For what? For appearing or answering or filing written statement. Now, appear within 30 days from service of summons, and then again 60 days, again extension can be given, so maximum 90. Further period also may be given. If any further reason is there, then it can be also extended, even though it is here given is maximum 90. Order 8's interpretation is that beyond 90 days also it can be given. Now, it says that if defendant has appeared at the presentation of plaint and admitted the claim, then summons is not needed. Now, appearance of defendant by either in person or pleader along with other person able to answer. Okay. Now, what is this requirement of summon? It has to state all the date, time when he has to appear, place where he has to appear, regarding what he has to appear. A copy of the plaint is to be furnished, sign of judge is to be given, seal of the court is to be given, all of that is to be given. Copy of plaint has to be accompanied with summon, and court has the power to direct defendant plaintiff to appear in person also. Personal appearance if needed, that can be directed as well. And when party cannot be addressed in order to appear in person, if party resides within local uh, jurisdiction, then only he can be attended. Or if it is outside the local jurisdiction, then if not less than 50 or 200 miles away from the court, then only personal appearance can be done. And for 200 miles, certain distance has to be covered, 5/6 distance has to be covered by public transport, then only it can be ordered. Now, summons can be issued to settle issues or final disposal of suit, and rule 6 says court to fix date for appearance of the defendant. Now, summons to defendant, if it is for producing a document relied on by him, then he can simply produce that. And if you're directing the defendant to produce his witnesses, then it has to be directed that yes, it is for final disposal and you are asked to appear and give the witnesses. Now, summons, how it may be served, who may deliver or effect of service of summons. Rule 9 says court will serve it within the jurisdiction. How it will be served? It will be sent to the proper officer and his subordinates, and outside the court it will be sent as either by registered post or registered courier or courier recognized by high court, or fax or electronic mail. Now, expense of the summons will be paid by the plaintiff. Now, High Court can decide the courier, which are the recognized couriers, and deemed service of summons when court receives or an acknowledgement or receipt signed by the defendant or agent that it is refused by the defendant or agent to accept, or tender by mail, fax, speed post, and court declare that summons is duly served. Now, rule 9A is by plaintiff when allowed by the court. It is a dusty summons. So he has to take the summons and serve it himself personally. The plaintiff will serve on application of the plaintiff. It can be given. Dusty summons, if it is not served, then it has to be served again through regular mode. Now, mode of service, by delivering or tendering a copy of summons signed by judge or seal of the court to the defendant, it can be delivered. Now rule 16 says person if served to sign acknowledgement on original summons. Now endorsement of time and manner of service by serving officer and endorsement has to be given as well. Now if there is a doubt as to whether service has been done, the serving officer can be examined on oath as well. Rule 30 is 20 is sorry 30 is substitution of letter of summons. When according to court defendant is rank entitling him a mark of consideration, then here instead of summon a letter can be issued. Letter can be sent through post or special messenger by court or any other manner. Now to the either to the defendant or his agent it can be served. Or if there are several defendants, then each defendant is to be served. If defendant in person, then on defendant or agent. If agent on agent by whom defendant carries on business, then agent or manager it can be given. On agent in charge of immovable property, then to agent it can be given. When service on adult member, if defendant not in residence, not found in time or no agent, then to adult member it can be given as well. And when defendant refuses to accept or not found, then affix copy of the outer door of house or conspicuous part. Substituted service, if court believes that no way to find him, then copy in conspicuous part of the courthouse, conspicuous part of the house where the defendant stays or carries on business or personally works for gain, or service and advertisement in newspaper in defendant's locality. Where defendant resides in other jurisdiction, any court where defendant resides, through that summons can be served. Summons in presidency towns, then small causes court of whose jurisdiction it is to be served. If defendant is prison, then officer in charge of prison. If defendant resides outside India, then to defendant where he resides. If summons in foreign territory, to political agent or court in territory. If civil public officers or secretary of railway or local authority, then to head office. On soldier, sailor or airman, then it should be served to the commanding officer. Okay. Now coming to appearance and non-appearance of parties, it says order 9. It is applies to both plaintiff and defendant. So if they don't appear or do not appear, then accordingly some steps can be taken. So it says that parties to appear on the date fixed in summons for defendant, and they have to appear or answer in person or by pleader. If the if the dismiss it's rule 2 says if because of the plaintiff's failure summons is not served, then suit will be dismissed. If plaintiff fails to pay the fee or postal charge or present copy of the plaint under order 7 rule 9, then suit will be dismissed. But if the defendant appears himself on the date fixed, then dismissal will not be done. Okay. Now when no party appears, that means both parties do not appear, then what will be done? The suit will be dismissed. Suit will be dismissed. The remedy is that under rule 4 you can bring a fresh suit or apply for setting aside. Now rule 6, if plaintiff only appears and defendant does not appear, and if it has to be checked whether summons was duly served. If summons was duly served, then decided ex parte. Okay. And if summons is duly not served, then court can direct plaintiff for second summons to defendant according to rule 5. Now if summons is not served in time, then postpone the hearing of the suit. Rule 8 says if only defendant appears and plaintiff do not appear, then in that case you dismiss the suit. And rule 9 says no fresh suit or appeal for only application for setting aside can be made. Now rule 5 is dismissal of suit on plaintiff's failure. If for plaintiff's failure fresh summons cannot be served, then fresh summons is to be given to defendant within 7 days. But if plaintiff also does not give that, then in that case what will be done? The suit will be dismissed. The remedy against that is fresh suit can be filed. Now except if the plaintiff can show that he failed to discover the defendant's residence after using his best endeavor, or defendant avoided the service of process himself, or any other cause to extend time, then time can be granted as well. Now when defendant appears on adjourned day for hearing, at or before hearing, and show causes for non-appearance, court may rehear him as if he had appeared on the fixed date. Now rule 9 says decree against plaintiff for non-appearance under rule 8 bars fresh suit. A remedy against dismissal is only set aside the application. Rule 14 is no decree set aside without notice of the opposite party. Now non-appearance of the several plaintiff or defendant, if several plaintiffs are not appearing, then court may proceed. If several defendants are not appearing, then also court may proceed and pronounce judgment later against the defendant who is absent. Now, rule 13 is setting aside ex parte decree. Once he is ex parte made ex parte, then suit will be heard, and then after hearing, a ex parte decree is passed. Now here, if ex parte decree is passed, the defendant's remedy is what he may apply to set aside to the same court to set aside that ex parte decree, and if the court is satisfied that summons was not duly served and or he was prevented by sufficient cause to appear on the fixed date, then he will set aside the same and proceed with the suit. If the decree cannot be set aside against only that defendant, then it has to be set aside against all or any of the other defendants. And if ex parte decree passed on ground of irregularity in service of summons and defendant had notice of date of hearing and time to appear and answer, then in that case it will not be set aside. And when there is an appeal preferred or disposed of, then in that case you cannot file an application for setting aside the ex parte decree. Okay, because you have you have concurrent remedies that you can go for appeal or setting aside, but if you go for appeal, then in that case you can't go for setting aside again. Okay, this is it. Let's, yes, order 9, let's keep it today till that, and from order 10 onwards we will start tomorrow and finish it. Okay, that is order 10 onwards we will discuss tomorrow. Okay, so this is our first part of CPC marathon, and tomorrow we'll complete the second part of marathon of CPC and complete the CPC. Okay, thank you all, we'll meet tomorrow.
Thank you, sir.